All right. Thank you for coming today. We got a couple of different things to deal with today, including the estimates and a discussion about the joint investigation into Facebook and the Cambridge Analytica matter. Mr. Angus?
Yes, just before we started, I wanted to give committee notice that I would be bringing forward a motion for us to discuss about a possible summons of Ms. Sandberg and Mr. Zuckerberg from Facebook.
Great. Thanks very much, Mr. Angus. And with that, opening comments from our Privacy Commissioner.
Merci, Monsieur le Président, membres du comité.
Thank you very much, Mr. Chair and members of the committee. Thank you for this opportunity to appear before you today to discuss the 2019-20 main estimates. With me today are Brent Homan, the Deputy Commissioner, Compliance, Greg Smolinek, Deputy Commissioner, Policy and Promotion, and Danielle Nadeau, Deputy Commissioner, Corporate Management. In the time allocated, I will discuss some of our plans for the coming year and how we expect to make use of the new funding announced in the recent federal budget, which comes in recognition of growing demands on my office. Our annual resources have been approximately $24 million in recent years, and we hope to have, of course, your support in maintaining that funding. We plan to use the additional resources to enhance our ability to deliver on our mandated obligations in the face of the exponential growth and complexity of the digital economy. Privacy issues are multiplying rapidly and often adversely affect Canadians' privacy. It has been an ongoing challenge to keep pace with those advancements and to protect Canadians in the way they deserve. We require program integrity funding to enhance our capacity to protect the privacy rights of individuals and achieve meaningful results for Canadians. Of course, we welcome the recent federal budget announcement of additional resources for my office. As a positive step, it would allow us to take concrete steps towards implementing our proactive vision for privacy protection. And I use the conditional tense would because even though they have allocated funds for our office, access to this funding depends on the approval of the Treasury Board, which has not been granted yet. Part of the funding included in the federal budget is temporary to help us deal with a backlog of complaints. While we have undertaken initiatives such as the increased use of early resolution and the revamping of our investigative processes, we have nevertheless struggled to respond to complaints in a timely manner. We currently have a backlog of more than 300 complaints older than a year. The new funds will allow us to reduce the backlog to approximately 10% of its size by 2021. We would also be in a much better position to achieve our goal of meeting service standard targets in 75% of cases. Ultimately, we think the best solution in the enforcement area is to modernize legislation, in part to give the OPC greater authority to manage its caseload according to risk. We need the discretion to focus our efforts on those cases with the greatest impact on Canadians. The second reason that we need this new funding is because of breach reporting. Our compliance Since mandatory breach reporting requirements came into effect under PIPEDA in November 2018, our office has seen the volume of reports increase to more than 5 times what it was when reporting was voluntary. At present, we can only superficially respond to the vast majority of private sector breach reports to our office. New resources would enable the OPC to more thoroughly review 40% of private sector breach reports to our office and 15% of public sector breach reports.
The federal budget provides additional funding is in the area of public education and guidance. The number of privacy issues for which parliamentarians, businesses, and individuals require our advice and guidance is multiplying at a rapid pace. In the past 5 years, requests for advice to Parliament have risen considerably, and this trend is expected to continue. Calls for various parliamentary committees are up 41% from 5 years ago, and in 17-18 alone, we made 34 parliamentary appearances and submissions. Clearly, privacy is becoming a very important issue for parliamentarians. In the coming year, we will remain responsive to parliamentarians' requests for advice on the privacy implications of bills and studies, and we will seek to contribute to the adoption of laws that improve privacy protection. New resources would also help increase our capacity to inform Canadians of privacy issues relevant to new technologies, their rights, and how to exercise them. As well, we would be better positioned to guide organizations on how to meet their privacy obligations. With current capacity, we can produce a maximum of 3 new pieces of guidance a year. Following our consent consultations a few years ago, we have developed an ambitious plan for much-needed guidance related to a wide range of important issues, guidance that we were asked by stakeholders to produce. Guidance to be developed over the next few years include important issues such as biometrics, the Internet of Things, social media, and de-identification, among others. As well, existing advice and guidance needs to be updated to ensure that our website continues to be a trusted and comprehensive source for both organizations and individuals. There are over 150 guidance pieces on the OPC's website, approximately 40% of which are 5 years old or more. Another important area for our office is providing guidance involves our advisory services to both industry and government. The new funding would help support our work with industry proactively in an advisory capacity to better understand, advise, and help mitigate and privacy impacts at the design stage of their services. Finally, I would add that guidance needs to be complemented by sustained and effective communications and outreach to have meaningful or significant impact on awareness and understanding of rights and obligations. We would therefore like to increase our capacity to conduct more public education and outreach activities to have a greater impact on awareness and understanding of privacy rights and obligations. Of course, as you've heard me say before, our federal privacy laws require a number of very urgent reforms. As our recent Facebook investigation so starkly illustrated, we've reached a critical tipping point upon which privacy rights and democratic values are at stake. And I look forward to discussing those issues in an hour or so. In conclusion, keeping pace with the rapid changes in technology is going to be an ongoing challenge for our office. We will continue to make optimal use of our resources, the resources given to us to carry out our mandate, to have a greater impact on the privacy rights of Canadians. The recently announced new funding is an important interim measure and positive step towards achieving our targets as we await much-needed legislative modernization. Thank you, Mr. Chair, and my colleagues and I look forward to your questions.
Thank you once again, Commissioner. I just wanted to give you a heads up from the committee. I think it's been discussed amongst parties and members that we'll have 1 7-minute round per party, and then we're going to get right into the Facebook report, etc., if that's okay with you.
Sure.
So we'll start off first 7-minute round I think we're starting with Mr. Saini. Go ahead for 7 minutes.
Good morning, good afternoon, gentlemen. Thank you so much for coming. I'm going to keep Mr. Cherian, I read the report here, your operating plans, departmental plan, 2019-2020, and I just had a few questions on that, just for clarity. One of the things here was that there was a decrease here, and I'm just wondering, it says your departmental results, privacy rights are respected and obligations are met. And in the target, what was to be, percentage of complaints responded to within service standards. And you had 75% was your target, but it's been going down year in. So 68% in 2015, 2016, 55 in 2016, 2017, 54 in 2017, 2018. Is there a reason why that's happening?
I think a major factor is the complexity of the issues that we are investigating. Often they involve fairly complex technological issues, business models, technology. We have experts to carry on these investigations, but they are becoming more complex, and that takes time.
So when I look at some of the charts here, it says the information is not available. Is that because you've only recently started to collect data? Because if you look at the next line, percentage of informal OPC recommendations, percentage of Canadians who feel they know about their privacy rights, percentage of key privacy issues, it says, so is it because you've just recently started to collect that, or?
It's because the instrument, the departmental results framework, is new. The government has adopted a new policy on how to describe results for parliamentarians, and that's what we have done. And we are in the first year of implementation of that process.
Okay. So now it's the amount of money that you've asked for has gone up by about $5 million, if I'm right, from the previous year. Now, the one thing I did when I read the report is that you have now a mandatory breach reporting provision. Has that caused this increase, this backlog? Because now, rather than voluntarily, people have to, or organizations have to mandatorily.
It's one of the reasons why we're facing a higher volume, and in particular, if you look only at breach notifications, previously to November, organizations could voluntarily report. Now they have to when there's a material breach, and the volume of these reports has increased fivefold since November. So that's clearly a reason for the increased volume. It's not the only one, but it's an important one.
But one of the things is with the increased funding that you've asked for, I see here that you have planned to keep the human resources or full-time equivalents the same. Would you not need to hire more people to actually deal with the backlog?
We will. Currently, we have roughly 180 FTEs with around 195 individuals, not all of whom work full-time, but 180 FTEs. And with the new funding, we will likely hire roughly 30 more people.
Okay. And so my last question is this. Obviously, as you know, that the last time you came, you gave us an update on the Facebook issue, or on your inquiry into Facebook. That inquiry itself must have consumed a lot of resources, did it not? Or was it the same, you would have applied the same resources to that issue, or more resources applied to that issue?
We clearly applied more resources to that investigation than on an average investigation.
And did that cause other things to sort of slip behind?
Yes. So there was not only Facebook. Facebook was a very important investigation in the past year. Equifax was also an important investigation, and there were a few others. Okay. So we need to look at these issues thoroughly. They affect a large number of Canadians. That's the result.
Okay, so I'll pass the rest of my time to Mr. Skinnsmith. Thank you.
Just one question, which is when you speak about the rapid advance of technological change and you see more resources spent in the last year on larger investigations, and you mentioned a couple of them just now, when you look ahead and you see an increase in resources in this past budget, and I know you welcome that, but when you look ahead, is there a number that you would suggest this committee might recommend to government going forward to say, if we receive this amount, we could both accommodate the existing caseload, and we would also be able to accommodate what we expect to be the workload going forward?
In terms of the volume of complaints, I see the federal budget as bridge financing, allowing the OPC to function and to dramatically decrease the backlog in the next 2 years or so. And my hope certainly is that by that time there will be new legislation. It's a bit premature to say at this point how many resources would be required to implement a new system that has not yet been defined.
Fair. Thanks.
We'll go next of all 7 minutes to Mr. Gord. Go ahead for 7 minutes.
Monsieur le Président, merci au commissaire d'être ici.
Thank you very much, Commissioner, for being with us today. My colleagues were very inspired in their questions, but if we're optimistic, given the number of complaints you've had right now, will you be able to stabilize your office's budget, or do you expect to always or ask for more additional funding in the future. In terms of the complaints and investigations that are conducted after a complaint, as I explained, these budgets should allow us to considerably reduce or fully eliminate the backlog that we're facing right now. So we believe that in 2 years, we'll be able to break even, all things being equal, if the number of complaints remains relatively the same and the complexity as well. But within 2 or 3 years, I hope that there'll be new legislation in place for the private sector, and the number of resources that would be necessary to conduct complaints and investigate them under this new legislation will have to be quantified and examined when we know the procedure and how it will be conducted. But the short answer is that I'm rather optimistic that with the funding, if it is approved by the Treasury Board, if it is given under this budget, that the backlog would be quite manageable when the legislation will be implemented. In your presentation, you mentioned a 5-fold increase. Did you conduct an investigation on the number of complaints, or is this varied on the number of topics? The complaints and the procedures that increased 5-fold were specifically on privacy breaches. So on November 1st, 2018, there was a rule that took force, and it obliged companies to declare privacy breaches, important breaches. So that is what led to this increase in the number of complaints from the private sector. We wouldn't have seen such an increase otherwise. I think there was an important increase because the implementation of the new regulations, and now companies are obliged to report these breaches. Now that this legislation is in place, we should expect more stable levels now. I won't ask questions on Facebook because we're going to get to that later. But Canadians, well, do you think that Canadians are very worried in terms of privacy breaches? With all the outreach and awareness about Facebook, are people more or less aware of this reality? Or do you think they're more aware now? Do you think there's a difference? The concern level has always been quite high. When we do surveys, we realize this. But I think that Canadians and people throughout the world are more worried now. Facebook, Cambridge Analytica, and others have played a role in this, notably because this serious incident had consequences. These weren't just theoretical, these were real, concrete consequences to the election process. So everyone was concerned, but privacy and protection of personal information is a notion that can be somewhat theoretical for people, but with Cambridge Analytica, we saw concrete results, effects, and this did increase the concern level of Canadians. Thank you. I'll come back to Facebook later.
Minutes, Mr. Angus.
Thank you, Mr. Chair. Thank you, Mr. Therrien, for coming before us. You will be going to federal court with one of the most powerful corporations in the world. I think the maximum Canadian fine is something that I was told Facebook makes in about 60 seconds. So from Facebook's point of view, they're going to want to spend as whatever it takes to defeat you in court. In your legal presentation, will you have to be drawn on your existing budget, or will the Justice Department cover the extra costs of ensuring that the people of Canada are well represented in court?
We will pay for our legal costs, legal fees through our budget. We have a team of lawyers, some of whom plead, but we often rely on outside counsel as well for cases in the Supreme Court, for instance. This is a very important case, and I will draw on our budget to be successful. My intent, obviously, is to be successful and to have the court declare that Facebook violated PIPEDA. The company has treated our findings as a legal opinion. They will not be able to ignore the finding of the federal court, and the court's order will be binding on Facebook. You might say, but the fine will be inconsequential, perhaps, but there will be an order, we hope, at the end of that process, and that order cannot be ignored, and there might be consequences other than monetary to disobeying a court order.
Right. Well, my concern is making sure that you have the resources, because I've seen from, I've been on this beat for about 8 years, I guess, and the various offices of Parliament come before us to talk budgets, and there's always constraints and limitations. But your office, it seems to me, the mandate is changing dramatically different than the lobbying commissioner has always dealt with dodgy questions of lobbying here and there. The ethics commissioner deals with what is dealt with, and nothing against their work. It's very important work. But it would seem to me that, this office was created in 1977. The Privacy Act was passed in 1983. For the public sector, and then PIPEDA in 2000. When I came on this file, your office would be dealing with, lost hard drives, USB sticks, and the breaches tended to be, corporate mistakes. I mean, these were questions of corporate governance, lack of, protocols in the office. But what we're dealing with, the emergence of surveillance capitalism, is a very different beast, where there's, a direct corporate interference in the lives of citizens that is profoundly undemocratic by companies that have enormous powers. I guess the roundabout way I'm getting to my point is that is your role transforming from a regulator to an investigator? And if that is the case, should be rethinking how the office works, what your tools are, because to ensure the privacy rights of Canadians in this world that is emerging around us, do the old tools, are they sufficient enough?
They're clearly not sufficient. I've said this a number of times. I think Facebook is a perfect illustration of the fact that the current tools that we have are insufficient. I cannot make binding orders contrary to many other data protection authorities across the world, but I can bring them to court. And one could be concerned about whether we have sufficient resources to fight equally with a company that size in court. It's a fair question, but the federal budget has reserved not inconsequential sums of money for us. I will use them, and the Facebook federal court matter will be a priority. And if I see that I need more resources to have success, I will not hesitate to ask this committee, Parliament, the government for additional funds. We're not there yet.
Right. I think what really surprised our committee when we started to delve into this case with the Cambridge Analytica scandal was how complex it was, how difficult it was for our parliamentary committee to get answers. You're dealing with basically dark data by people who work in a very different realm than what we do as legislators. Christopher Wiley had stated that he felt that the UK ICO was very unprepared when it came to taking on Cambridge Analytica, just because they did not have the experience of knowing how these players operated. Now, fortunately, the ICO in the UK did an excellent report, but putting it to you in terms of the changing world we're dealing with of surveillance capitalism, and particularly data mercenaries that some of who we brought here, do you have the resources that are necessary to actually be able to play in that milieu of having the technical people, the people who know how the hard drives are being misused, how data is being moved around, because it's in a very, very different realm than anything we've dealt with in the past?
I think I approach this incrementally. First point of order, the law needs to change so that we have the right tools, the right legal tools to ensure compliance by corporations. And that won't happen immediately. But my hope is certainly that within very few years that this will happen. And then at that point, there needs to be a discussion around the resources necessary to make that system work. With the sums reserved for us in the federal budget, I think I asked for more, but we received a non-inconsequential sum of money to bridge us towards this new legislation that I hope will be adopted within a few years, within a couple of years. I'm fairly optimistic. Do we have all of the tools that we need, including resources? No. And choices have to be made. As any other regulator, you're right to point out that because of the exponential changes to technology and the digital economy, we have many issues and companies to monitor and look at, and we need to make choices. So we cannot go after all even serious problems. But the resources that were given in the budget will certainly make an important difference. And let's have a discussion around what shape the new legislation should look like, and then we can talk about resources necessary. I'll just, as a comparator, I would say with the new funding, our size would be similar to large European data protection authorities, but much smaller than the UK Information and Commissioner's Office. What is the right size is a question for discussion.
Thank you, Mr. Angus. Thank you, Commissioner Therrien. So we'll move into the second part of our meeting pursuant to Standing Order 108-3H, study of a joint investigation of Facebook, incorporated by the Privacy Commissioner of Canada and the Information and Privacy Commissioner for British Columbia. And we have, again, with us our Commissioner Therrien. We also have Brent Holman, Deputy Commissioner, Compliance Sector. Go ahead for 10 minutes.
Thank you. Let me just get my other papers. So you had a statement from me on Facebook. I'll use it liberally. Just a reminder. Alors, pour ce qui est des
In terms of the conclusion of our investigation, we noted that Facebook did violate PIPEDA on various occasions. First, the rules for consent. We looked at two types of Facebook users: those who installed third-party applications, and for these individuals, Facebook was relying on its privacy policy in the development of the app to make sure that the privacy of its users was being respected. However, when we looked a bit further and we checked whether there was any substance behind this policy, we noted that Facebook did not check, in fact, whether the policy, when developing applications, was properly protecting users' privacy. One of the examples of this that we identified with Facebook, well, Facebook is directly has obligations under PIPEDA, and when this company divulges information to a third-party application, it is unacceptable for Facebook to rely on its privacy policy, the privacy policy of the other company, to fulfill its obligations. Therefore, there was a privacy breach in this respect. Another type of user is one that is a friend of users who on Facebook who installed third-party apps. So when they signed up for Facebook, they gave their consent on Facebook to disclose their information when their friends installed third-party applications. This could have happened years before, when their friends installed third-party applications. The friends of the users had given their consent, well, according to Facebook, perhaps years before, and for things they were unaware of. So there was not informed consent, and that is one of the conclusions we also drew from our investigation. So they did not have informed consent in that case. In conclusion, our main conclusion was that Facebook violated one of the main principles of PIPEDA for companies that gather and use personal information. They're accountable for their management of personal information. And in our opinion, that is Facebook's main fault. They shifted the responsibility to either the users or to the third-party application developers for Facebook. Facebook even challenged the conclusions that we drew and fundamentally challenged our conclusion, stating that when third-party applications, well, when a user uses a third-party application, Facebook's disclosure of information to this party, well, according to Facebook, the sending of information from Facebook to this third party was not a disclosure, but rather a way of making information available to at the request of their users. So we can see how Facebook was able to shirk its responsibilities and ask other parties to take care of this. So in our opinion, Facebook does have a responsibility, a legal responsibility, when it discloses information to make sure that this disclosure is done with informed consent. One of the questions that we'll bring before the federal court is the fundamental question, is when Facebook does use Part 30s and sends information to third parties, well, we have to know if this is a disclosure according to law. Facebook doesn't think so, but we believe that the answer to this question is yes. Another point that I'd like to insist on is the difference between Facebook's statements stating that the company would like to adopt a position that is in favor of privacy, a privacy-focused type of activity, and its desire to work with governments and regulation agencies to better protect the privacy of its users. That would be nice, but in actual situations, we saw the exact opposite. While Facebook said it wanted to work with users and the various regulatory bodies, we had concluded, well, we had conclusions to provide them and recommendations for it to comply with federal law. And this was the result of a few weeks of negotiations and discussions with Facebook, and they challenged and rejected our conclusions and recommendations. And that was exactly the contrary of the position that they had stated, that it would help to protect and work with regulatory agencies.
Facebook, in our view, violated PIPEDA With respect to consent, we think the main violation is with respect to their lack of accountability. Again, PIPEDA's first principle is that companies have a legal obligation to be accountable for the way in which they handle the personal information of those from whom they collect information. They did not comply with that fundamental obligation. And at the end of the day, they refused to our findings, point one, and point two, our recommendations. I think it is untenable that the law is such that this is the state of affairs in which we are today. A company should not be able to say to a regulator, after the regulator has done serious work to look at the practices of the company, thank you very much, but we disagree. We don't think we're disclosing information to third-party applications. We think they're making that information available at the request of our users. Therefore, we, Facebook, think that you're incorrectly applying PIPEDA. It is completely unacceptable and untenable that as a regulator I am in that position, and that that my decisions are not binding on the company. So that's the plea that I'm making to you, and I know that you have agreed with our office in the past that we need stronger enforcement powers to make sure that companies do comply with the law. But I have to, in this forum, underline how unacceptable it is that we at the OPC are in that situation as we speak, and that we have to go to court to ensure that this company is under an order to comply with the law. I'll stop there.
Thank you, Commissioner. I will start off, first of all, with Mr. Erskine-Smith for 7 minutes.
Thanks very much, Commissioner. Thanks for the work of your office and the work of the BC Commissioner's Office. I want to start by quoting Mr. Zuckerberg recently at an F8 developers conference. He said, "Now look, I get that a lot of people aren't sure that we're serious about this. I know that we don't exactly have the strongest reputation on privacy right now, to put it lightly, but I'm committed to doing it well. The future is private." And then I read from your report, and you say, "We are disappointed that Facebook either outright rejected or refused to implement our recommendations in any manner acceptable to our offices. This is particularly troubling given Facebook's public commitments to work with regulators and rectify the breach of trust associated with these events. We are and in a different part of the report, you say, "We were disappointed that Facebook repeatedly failed to meet submission deadlines for the voluntary requests and provided incomplete or deficient responses to several of our questions, certain of which remain unanswered." So we have comments in your report. We have recent comments from Mr. Zuckerberg. Is there any reason to have confidence that Facebook is taking privacy seriously?
We have not seen it in the context of the investigation that we have concluded. What they say publicly, they have told us, we want to work with you, Facebook, want to work with you, regulator, OPC. Let's try to work together. But at the end of the day, again, they reject the legal conclusions and they reject the recommendations. So
saying one thing, and when they have the opportunity to act consistently with the words that they are providing to this committee and to your office, their actions fall well short of their words. Is that fair to say?
yes.
When it comes to fines, so we have the FTC talking about fining Facebook over breaches of privacy and a breach of a previous agreement with the FTC, and the numbers that Facebook has set aside, they've set aside ready to pay $5 billion potentially. We have the UK Information Commissioner levy a £500,000 fine, and she said, "We consider these contraventions to be so serious, we impose the maximum penalty under the previous legislation. The fine would inevitably have been significantly higher under the GDPR." And you are able to levy a fine in the amount of
I'm unable to levy any fine.
Interesting.
But after asking the court to review the matter de novo, not to review our report, but to review the matter de novo, the court could certainly make a declaration if they agree with our position that Facebook violated PIPEDA, and there could be damages which historically in the federal court have been in the tens of thousands of dollars.
Right, and a court would have to take it upon itself to levy significant punitive damages that they've never awarded before because there's not
Yes.
a strong statutory basis for doing
Yes.
so. You noted Facebook's privacy protection framework was empty, and is there? That was then. I mean, they have taken some steps. The privacy framework that you see in place, are you able to assess its current privacy framework, or because you don't have the powers to proactively audit and they've refused to implement or to agree to annual audits, are you able to realistically assess their current privacy framework?
The comment that the privacy framework was empty still applies. It is empty.
It is empty.
And I'll give you two examples. So the comment actually refers to the previous investigation by the OPC in 2009. So in 2009, my predecessors reviewed very similar issues, the consistency with PEPEDA of disclosure by Facebook to third-party applications. The OPC found that this was done on the basis of vague terms and conditions that did not represent meaningful consent. Facebook at the time agreed to make certain changes to its procedures, and it did. And when the comment, the framework is empty, is a comment about the framework adopted then.
So the framework was empty, and it is empty.
Yes.
In light of that, does it make any sense at all that a company that has failed to respect Canadians' privacy rights would then be implementing a dating app on the service that they're currently providing to Canadians? Does that make any sense at all to you?
No.
Okay, no, you don't have to go further on
Yeah.
that. It seems ludicrous. Okay, so you mentioned that the current laws are untenable, and I think that the current state of affairs, I would completely agree with you that they are untenable. It's interesting. I was in Brussels recently, met with the EU Data Protection Supervisor and other people thinking very seriously about privacy. They actually spoke very favorably of the ideas that have come out of Canada, both from Canadian privacy commissioners and from Canadian academics who have written about privacy. And their laws are based on our ideas, and our laws aren't based on our ideas. It seems an incredible shame. So last June, I introduced C413, and had that bill been law, you would have been able to make orders, and you would have been able to order Facebook to comply with your recommendations, and you wouldn't have to seek the help of the federal court. Is that true?
Yes.
And if that law had been in place at the time of the offense, at the very least, you would in fact be able to levy fines, and Facebook would not be facing $5 billion in the U.S., 500,000 pounds in the U.K., and zero in Canada. There would be some monetary sanction we would be able to apply here. Is that fair?
Yes.
And I guess the last question I have, which is I think you'll agree with me, we've thought a lot about improving our privacy rules at this committee, and I think Canadians expect that we will have a strong privacy rules in place. But if we don't have a strong regulator to enforce those rules, it doesn't seem to me that those privacy rules and the effort to strengthen the privacy rules is worth much at all. Is there anything as a first step that matters more than creating a strong privacy regulator here in Canada?
I would say there are at least two important solutions. One is to make sure that the regulator has the right powers, and in that basket would fall binding orders, penalties, and proactive inspection powers that I've discussed in this committee before and that I can expand on if we have more time. But I will move to another part of the solution, which I think is to ensure that we have rights-based legislation. Facebook Cambridge Analytica demonstrated the link between privacy protection and the exercise of other fundamental rights, in this case, democracy. But there's also a link between privacy protection and other fundamental rights, equality, for instance, in the employment context, freedom to go on the internet to develop as a person look for issues of interest without the fear of being monitored by corporations. So ClearLink demonstrated in Cambridge Analytica, but it's just one example of the clear link between privacy protection and the exercise of fundamental rights. I think that shows that in addition to giving powers to the regulator, the new legislation has to be framed as perhaps principles-based, as PIPEDA is, but also rights-based, and recognize that privacy protection is linked to the exercise of other fundamental rights, and that we are all at risk if privacy is not protected, not only that we will lose our privacy, but that other rights are also at risk.
Thank you, Mr. Erskine-Smith. Next up for 7 minutes, Mr. Gourde.
Merci, Monsieur.
Thank you very much, Chair. My question may seem rather general, but it's about the consent of Canadians. The consent for Facebook apps. Sometimes the page appears and then you clicked on the accept button below. Last year we talked about informing Canadians more about what this consent means. This consent is written by Facebook or the various apps, and it brings us to accept even future applications that aren't even indicated in the consent. They don't say it, and people are in such a rush to get to the app that they accept automatically, and then Facebook can defend itself saying that Canadians accepted this. So is there a way we can inform Canadians about this type of kind of contract they accept indirectly by clicking on accept? Is there a way we can allow Canadians to be aware of this? In terms of current policies that Facebook has, well, we investigated them, and we believe that there was not meaningful consent because sometimes several years later, things were produced years later, so there should be 50 pages of it could be 50 pages of legalese, but if Canadians aren't informed, this is not meaningful consent. There should be guidelines. Well, in January of this year, we did establish them to allow companies to have clearer privacy policies. That's one part of the solution, but that's not the entire solution. That's one of the reasons why I am in favor of adopting a new Privacy Act that goes beyond important principles such as consent. Yes, this is important, but that's not the whole solution. We need to have legislation that is general enough to define privacy. Privacy is not just consenting or not. That's one part, but privacy is to be able to communicate with our friends on social media without fear of a company constantly surveilling us. And then they use this information to try influence our political opinions and our vote. So we need to establish right to privacy at the proper level, and this goes beyond consent. Moreover, I have in front of me a bill that was tabled by the previous government that defined as the right to privacy to the right to be free of any surveillance. So with new legislation for privacy protection for both the public and private sector, we should start here. What is privacy? Is it consent? No, that's not enough. Privacy is the right to have your physical intimacy respected. It is the right to be free of any surveillance. It's the right to have control of your private communication and it not be intercepted by the state or by companies. That has to be defined in law, and then we have to have other mechanisms such as consent that support privacy, but privacy is not limited just to consent. So, after such legislation, we should be able to establish a framework for consent and impose it on Facebook. Facebook shouldn't be able to propose its own consent. We should have consent that would better protect Canadians under Canadian law. The application, this would be, has its own laws, and this would be complicated if we define at the right level of generality and importance. We won't be in the situation that you're describing, where a company can tell someone, well, our contract told the user that we would use their personal information for such and such a reason, and that they consented to it. So we're acting to comply with the law. But if we do have legislation focused on rights, where consent is part of this, but not the only aspect, and corporate surveillance, whether it's consensual or not, and if it leads to corporate surveillance of an individual's activities, then regulators would have the power to intervene. Because even though consent was given, privacy was not respected. Thank you.
Mr. Angus.
Thank you, Mr. Chair, and I want to say at the outset how important the work of your office is. I think for too many years we've been played for suckers by Silicon Valley, that it was about choice, that it was opt-in, opt-out. You know, we could read the privacy provisions. They've never respected the privacy provisions in building their models. What we've learned with Cambridge Analytica and Facebook is that this is not simply a question of the rights and the choices of consumers. This is about the democratic rights of citizens. It's about the questions of a nation state being able to actually ensure that its citizens can live in a world where they choose certain rights that are protected and inalienable. And one of those rights, as you said, is the right to be free from surveillance. So I want to start off with just a few simple questions. So your finding was that Facebook broke the law of Canada with its breach of PIPEDA. Is that correct? And as an officer of Parliament, you have been mandated to ensure compliance of PIPEDA. So was your report an opinion, or is that a finding of fact by the officer in charge of representing the Parliament of Canada in preserving our laws?
It's a finding of fact in law.
Finding
that
of
is
fact
that
in law.
under the current law is not binding on the corporation being monitored by this agency.
And so Facebook initially stated that you didn't have jurisdiction because you couldn't prove that the 620-some thousand Canadians who had their private information stolen, that they weren't somehow affected. Did then they move on to say, well, it was an opinion of yours and they'd take it under advisement? I mean, where are they? Is it your opinion, or that the fact that we don't have jurisdiction? What is Facebook's response to you on this?
They raised the jurisdictional question. We've answered it in our report. They never acquiesced to our jurisdiction. They pursued a discussion with us as though we had jurisdiction, but never conceded that we had jurisdiction. So that's the state of affairs. If Facebook raises this issue in the federal court, when we file our application, the court will decide whether we have jurisdiction.
So when we began our hearings, and I first wrote to you, it was the spring of 2018 when the Cambridge Analytica scandal had just blown up, and we had found that 620-some thousand Canadians had their information taken, and Facebook was made aware of that in 2015 and made no efforts to tell Canadians. They said at the time when they came to our committee in 2018 that they had a very robust response. it seems to me, I'm flabbergasted that a company would look at a finding of law and say, well, we simply don't recognize your jurisdiction. Are you aware of other examples of companies saying that in Canada?
I don't, but there may be other regulators who do not have the authority to make binding orders, but nothing comes to mind.
Well, I was trying to think of a comparison. I was imagining when we have automobile recalls because of numerous accidents, that if an automobile company came back to us and said, yes, there were multiple accidents in Brazil, multiple accidents in the United States, multiple accidents in Britain. However, since you couldn't prove that anyone died in the highways of Canada, we don't recognize your role as a regulator to make us fix the fundamental problems in our vehicles because, and I just want you to correct me if I'm wrong, they said it would cost too much for them to comply with the laws of respecting the rights of Canadians. Would that be a fair comparison?
It's a good analogy that, so we were in discussions with them as to whether their privacy policies led to meaningful consent. They disagree that they did not obtain meaningful consent, but moreover, part of their arguments were, but in any event, there was no harm. No Canadian was harmed. You haven't found evidence that Canadians were harmed, which is a good analogy to your car accident example. So because we did not demonstrate harm to Canadians, you have no jurisdiction. Well, actually, point one, the legal foundation leading to risk and potential harm to Canadians we found was unsound, contrary to PIPEDA. And point two, we have seen harm in the US and in the UK based on the same weak legal foundation. So the same risk that manifested itself in the US and the UK could very well occur in Canada. And what we looked at was the terms and conditions. Cambridge Analytica was one manifestation of one third-party app. Facebook has millions of third-party applications. Clearly, there is harm for Canadians.
Well, I guess this is my question. I'm not a lawyer, but I'm thinking the basic concept of jurisdiction, and correct me if I'm wrong, I would think that jurisdiction means the country of Canada, of which you are a regulator, and citizens, 620-some thousand Canadians had their data taken because of this breach, that Facebook was aware of it for 3 years, made no efforts to tell Canadians that within the jurisdiction of Canada, they broke the law because they did not make any efforts to let any Canadian know that they had been the subject of this breach. Is Facebook putting forward the position that jurisdiction only counts, that jurisdiction only exists, if you can actually prove that Facebook physically caused harm by its actions?
It's pretty close to the position that we heard from them. They're not challenging our jurisdiction on the basis that they're in the U.S. or anything of the kind. They're challenging our jurisdiction on the basis that the terms and conditions we were examining did not, in their view, result in harm, and the absence of harm led to absence of jurisdiction. We think that we have jurisdiction because we have jurisdiction to look at the legal, what I call the legal foundation, i.e.
Well, you have
the terms and
jurisdiction
conditions.
because you're there to protect the rights of the citizens of our country as mandated by our parliament. Is that not how jurisdiction works? And your obligation is to protect our citizens,
And they're engaged, Facebook is engaged in commercial activity, which is subject to PIPEDA, which gives us jurisdiction.
Thank you.
Thank you, Mr. Angus. Next up for 7 minutes, Mr. Picard.
Merci, thank you. Est-ce que vous avez regardé
Did you look at the two-part documentary on Facebook? I think it was on HBO. No, some of my colleagues did, but not me. In this documentary, it talks about Facebook and Cambridge Analytica. And obviously, the questions that were asked to the former executives of the companies have led us to understand that they were somewhat naive. They were not at all aware about the impacts and their legal obligations with regard to the information they received from people. One of the essential points that the safe harbor agreement, so that the company could not be accused of the actions in question because the company didn't believe it was subject to the law. The structure and the nature of its activities kind of meant that it slipped between the legal cracks. And is this hypothesis applicable? Because it is the case for this company. There was a loophole in terms of its activity, and they say that they're giving X service which protects it from any prosecution. The arguments in terms of jurisdiction that Facebook has put forward have nothing to do with their territory, the location where data is located, and the safe harbor notion may call this scenario into question, but they said that we weren't able to show real harm that was done to Canadians, and that therefore we had no jurisdiction in this area. I don't think that the safe harbor notion is an obstacle to jurisdiction here. You talked about the lack of awareness. And yes, that's possible because at a certain time, this company and its executives were somewhat naive and not aware. I have concrete experience that has brought me to believe that there wasn't just a lack of awareness. The executives said they want to do better, and regulators have told them, you must do better because you did breach the law, and they're aware of this, and they have decided not to do so. In the documentary and the video, it says that they're going to work with regulators to meet the government's obligations. And they did not follow up on what they said. Given the nature of Facebook services, well, I could compare it to a highway. They can pave the highway for traffic. There's commercial traffic, individual traffic, advertising, all sorts of traffic. Things are flowing freely on the highway, and we have to pave it as widely as possible to allow the maximum amount of traffic. And if someone were to look at the traffic on the highway from the side of the road, a third party could look at this, and the very nature of its activity, in their opinion, could allow them to shirk their responsibility. I'm trying to explain arguments in their favor to make sure we have all the tools to perhaps look at even more coercive measures than we are. I don't know about that analogy, but I think one of the positions that we could take is that, well, what they're a company, they work with consumers, but they also work with other companies. And it's the other companies that gather information from users. So Facebook believes it's not responsible for what other companies do. They're only responsible for what they do, but not the activities of other companies. So that could hold water if we're not for the fact that Facebook has commercial interest in having a lot of traffic on its site, and other companies collect information. It's not a sin to make money on Facebook, but when you develop these business ties and Facebook's making money off it, thanks to the presence of third-party applications, this does mean legal action. That's the nature of its agreements with a third party. If they do not behave properly, they would be responsible. In terms of PIPEDA, That is one of the fundamental issues that we'll have to look at the federal court. In our opinion, what is happening is disclosure on behalf of Facebook to the third party. The user provides Facebook with information. Facebook has this information and they disclose it to another company. That is one type of disclosure that does have legal consequences. Facebook has to make sure that the user has provided informed consent to this activity. And in our opinion, this means that Facebook is not responsible for what these other companies do, in its opinion. Here's another hypothesis, rather unlikely, but the Facebook market in Canada is roughly the same as that of California. So if we give them a really hard time, they might just close Facebook in Canada. Would that be a consequence that could happen? Could we live with this? And is this kind of a dead end that we're heading into? I would look at this like this. Facebook is successful because people want to communicate with their friends and their family members online. That's a real need. Can we fill this need with Facebook only, or are there other companies that we could use on social media to meet this need? That may be complicated. There'd be less people on that network, but that's how we have to look at things. If a company, no matter how big it is, decides to shut its doors because it's not complying with our laws, well, there could be other players, in my opinion, that could take their place because they do meet a real need, but it has to be done in compliance with the law.
Gentlemen, for your rather honest and sometimes disturbing testimony. I'm a guest today on the committee, so I ask you to bear with me. What recourse besides stronger or in the absence of stronger legislation do we have to deal with the what you've stated that Facebook has violated PIPEDA? And is there any?
Legally, nothing in terms of privacy violations.
Yeah. My follow-up question to that is, I'm wondering how much of Facebook's actions are due to maybe perceived weakness among our position. One of the things I find very disturbing out of all of this, and this comes out of another committee I serve on, is government advertising. We're moving all of our advertising out of local Canadian newspapers, radio, and pushing it large share to Facebook. And I'd have to wonder, just the laughs they might be having in their head office knowing they're fighting with you over PIPEDA, but at the same time, the government is pushing taxpayers' money to them. And then yes. I look through your departmental results. I look at, how we as a government take privacy rather less seriously. Like I'm looking at a National Post report about when National Post reporter asked a question of PSPC and DND, and within an hour and a half, they got a threatening phone call from the owner of Irving, the president of Irving, threatening a lawsuit because PSPC and DND gave away private for the third time. The government gave away private information to a corporation. I look at your departmental results, and we look at, the percentage of, government organizations that are informed and guided to protect privacy rights. Our target is only 60% of government organizations to actually follow our own rules. So I wonder, does Facebook look at this and just think, these guys aren't serious about privacy anyways? Why should we be? Oh, and by the way, at the same time, we'll take taxpayers' money from you. I'm outraged, frankly, the stupidity of it all, that at the same time you're fighting against them, the government's handing them checks. And at the same time, yeah, still. Yeah.
My answer
another one,
My answer would be this. So a number of actors in society could take action to move away from companies that violate their privacy. The government has spending powers for advertising, but often the case is made that individuals also have a choice and could decide not to be on that platform. But the fact remains that Facebook has 2 billion users on it, and it's not easy for an individual to withdraw from that service. It's possible, but it's not
we could
obvious.
switch back.
Which leads me to the solution. I do not think is for individuals to have all of the responsibilities, and perhaps government could take some action in refusing to do business with a certain company that may have more impact. But that's not the true solution either. The true solution is to ensure that companies that meet a need in society, and clearly there's a need for people to communicate, do that in a way that respects the rights of Canadians, and that means legislation.
Do you get a sense that Canadians, like there seems to be a lack of outrage over it? There was a blip with the Cambridge Analytics, which was very serious. Do you get the sense day-to-day Canadians are just saying, well, it's a free service. If people don't want their privacy taken, don't use it? Is there just a lack of understanding of how serious this is, or
I think people use these services because they have a need to function in a modern society, and modern society includes social media and relying on digital services. They would rather do that in a way that does not put their privacy at risk, but they feel that they have to do that. Again, I think our task is to ensure that Canadians can have the benefits of the digital economy, but in a way that does not create harm for them, which brings me back to legislation.
Thanks.
Thank you, Mr. McCauley. Next up, we'll go up for 5 minutes to Ms. Vanderbilt.
I think the previous question actually goes to the heart of the problem, which is the dilemma that you have these big dataopolies, and choice is really not a real choice in terms of users or anybody else. But what I'm interested in is when you started this investigation, of course, it was Cambridge Analytica and Facebook and the data breach, and we on the committee have found that aggregate IQ is an integral part of that. That study, I understand, is still ongoing.
Also jointly with our BC colleagues, and we hope that later this spring we will be able to announce our conclusions.
And without preempting the conclusions, is there anything that you anticipate coming out of that study that would add to your recommendations on what this committee...
On legislation?
Correct.
It's difficult to say, and if I say, I may disclose the conclusions prematurely.
We'll wait in great anticipation for the report.
Okay.
The concern that I have, and you mentioned this a little bit earlier when you said that Facebook has millions of apps. The Cambridge Analytica, that is just one app.
Yes.
And we've been told in this committee that this is just the tip of the iceberg. And we know there are many other data platforms, social media platforms. Do you have concerns beyond Facebook of other data platforms and if so, how would you, given that you don't have the proactive ability to investigate, how would you recommend that we make sure that we are able to investigate when these kinds of breaches may be happening in places that we're not even aware of yet?
Of course I'm concerned. So right now, under the current law, we investigate based on complaints largely. We initiate a few complaints ourselves, but that's truly the tip of the iceberg. I think the proactive inspection powers has to be seen in the following light. We will never, as a regulator, be able to monitor the activities of all companies. That's not the point. But if we have the authority to proactively inspect practices where we think there might be something untoward happening, and then find, in some cases, that something untoward is happening, and that carries consequential penalties, that sends a message to the whole industry that if they violate the law, they are at risk of being inspected by the Office of the Privacy Commissioner and incurring these fines. So I think with a system like that, there's much greater chances that behavior across the sector will be improved.
So they're intricately intertwined, the ability to proactively investigate and be able to impose penalties. With regard to Facebook, the fact that they didn't implement the recommendations in 2009, they've rejected that there was even acknowledged wrongdoing in this case. Do you believe that the kind of thing that happened with the Cambridge Analytica, and in terms of when people in Canada today are on Facebook, could that still happen today?
There's no question that it could happen today.
And not just on Facebook, but on other platforms as well?
It could. I haven't investigated others, but I assume that what is happening at Facebook may be occurring elsewhere. But certainly with Facebook, yes.
So as a committee, I would imagine that there's a lot of urgency then in terms of our need to be able to legislate so that you can have the kind of powers. Now, going to the federal court, that obviously would allow penalties, but your estimate is that would be another year. It would add a lot of time, and then we wouldn't be able to have that kind of urgency in terms of your investigations. Is that correct?
It would take a year, but after a judgment by the federal court, then I think we would be in a much better position. But I'm not sure that the legal proceedings would stop at the federal court. I think what is at play is sufficiently near to the business model of the company that I think it's likely that this matter would reach appellate court level. So I think it's going to take some time.
Thank you. Do I have time?
Not anymore. Just at 5 now. So thank you. Next up for 5 minutes, Mr. Gord.
Je trouvais ça intéressant.
I find this very interesting what you're saying. If it goes to the appellate court, this won't happen overnight. It could take some time. Well, we want to be optimistic still, but the reality is that this is the digital Far West right now in terms of regulations in Canada. Are there any other countries where they've taken joint action or legislation that has sent a signal to Facebook and the other big corporations of this type? Have we defined framework in other countries? Sometimes they do something, they don't face legal proceedings, and, well, individual countries take actions, but they could be similar, but, well, we could have an international treaty. That wouldn't happen overnight, in my opinion, but we could think that if various countries were to adopt similar legislation that was interoperable, so if all these actions from various countries and their governments, joint actions, could lead to a result that would be encouraging. Europe, as you know, has already adopted legislation that would give good protection in terms of privacy. It's been in place now for a year, and I'm encouraged by the fact that in the US, there are serious discussions underway with regard to privacy legislation. So when our trade partners and other countries in Europe and in the South and in other Asian countries are heading in this direction as well, it leads me to be more optimistic, but it'll take some time. At the end of the day, adoption of a more severe law in several countries, including those that are Canada's trade countries, well, this should improve things. I think that Canadian legislation would be more binding with regard to Facebook than in the U.S. The U.S. system has allowed, Facebook to give a lot of money to the Congress, and they've been given some freedom and latitude given that reality. But other countries, such as the UK, Canada, Australia, with the political systems we have, may go further. You've taken a certain strategy, little steps. So should we test it properly? The first person who will adopt this strategy may have to adjust it, but if one country does it at a time and then they have to adjust it along the way, well, we could send a message that we're taking this seriously. I think it's important for all countries to act. They shouldn't wait for their neighbors to act. All countries need to act. And it brings us back to the conversation in the beginning. Technology is evolving fast as our business methods. We shouldn't think that if we adopt a legislation and then amend it, it'll be good for the future. The legislation has to be effective when it is adoptive. It has to be flexible enough to be able to meet technology changes. But parliamentarians also have to be aware of these changes, and they have to take them into account. When technology identifies weaknesses in our legislation, and these changes are happening at a very fast pace, and one of our key problems is that legislation cannot keep up to this pace. I can't ask for legislative amendments every 6 months, but we should have a flexible enough framework to take account of technology advances. And also, we should think that we may have to change the law in 5 or 6 years because technology is changing very quickly. So this legislation should have to evolve and be proactive to the situation. Yes, exactly. Do you think a government should make this a priority for the future? Absolutely. Answer. That's your priority, but should it be a priority for future government? The most serious consequence as a society of business practices that undermine the integrity of the democratic process, well, that's the first of many reasons why we have to act, why it's urgent to act. And it should be a priority for any new government. They need to create legislation for this. Thank you.
Up on the slate, we have Madame Fortier and then Charlie Angus to finish. Go ahead, Ms. Fortier, for 5 minutes.
Merci beaucoup.
Thank you very much, Chair. I'd like to thank you for being here today. We may be repeating ourselves a bit. I hope I haven't done so, but it's really clear that the topics are very complex, and we have to find a way to move with this constant evolution. You answered several of my questions, but in what you said earlier, you mentioned that we have to reform legislation. That's clear, and you also said that we have to make companies more accountable. You may have already said this, but in 2 minutes, could you explain what you mean by this? Under current legislation, the key principle of accountability, in French we say responsabilité. So accountability, in the accounting sense, if I understand correctly, means we're accountable or responsible. A company that is accountable has to provide a report on its activities to fulfill its obligations. Under current legislation, PIPEDA, accountability is said in French as responsabilité, and responsibility. This comes before accountability. This is already quite a bit, but responsibility is responsibility for adopting procedures to implement other principles of the Act, transparency, consent, etc. So the company fulfills its obligation by adopting procedures. But they're not obliged to be accountable to its users or to the regulators to show that these procedures implement the principles of the Act. So one of the consequences of Facebook, and there's other examples of this, is that we can no longer trust. It's the principle of responsibility. Companies have to be responsible, accountable, and the burden of privacy doesn't just rest with users, doesn't just rely on them. It would be unrealistic to believe that users should be fully responsible for this. So it's important for companies to be accountable as well. But Facebook and others have said that even though this is imposed under law, that they will be respecting it. And that's why they have to be accountable. We have to force these companies to show that they have complied with procedures and created them to implement principles of this Act. And if we combine this with proactive inspection powers, well, one model, for example, would ask companies to report to regulators on the procedures they've adopted, kind of like what we do with reports that are now legally in place for several years. A company would have to report to a regulator about the procedures it's implemented to comply with PIPEDAS principles. And the regulator has limited resources, but it could look at the report and it could note that on certain areas there may be issues. And so they conduct inspections of these companies, and they may find that there are infringements and impose penalties. So if that's how accountability really worked, if there was real accountability in accountability terms, then, once again, this system could have an impact on the entire industry, because companies wouldn't want to run the risk of an inspection or of a penalty. Thank you. One last question. Are there questions that us as a committee we haven't asked yet that you would suggest with the time we have left before the end of this Parliament, but also for the future as well? I think the question of accountability is fundamental. You may have heard that industry representatives have said that in the modern technology world, consent is not always realistic. And companies can take over and be accountable for the way that they deal with information. We have no problem with companies being partially accountable, but we have to seriously think about the fact that this is not enough. We can't just make companies accountable. We have to have an inspection from an independent agency that acts on behalf of individuals, as individuals are not often able to identify issues. So companies know what their business model is. They're generally accountable, but we need a third party to ensure that the interests and rights of users are being respected in real situations. Thank you.
I want to follow up on your comments about accountability, because I'm trying to think of a similar situation of corporate lack of accountability. Facebook has an enormously successful platform. It's used all over the world. They're making unprecedented money. They have no competition. And yet in this past year, the UK Parliamentary Committee has made a finding that they were called, quote, digital gangsters. The Privacy Commissioner in New Zealand found them to be morally bankrupt. That was his quote. They were denounced by the UN for complicity in the Myanmar genocide. It would seem to me that normal corporate practice would be to get on a goodwill tour and start to fix the problems and reassure people, and yet Mr. Zuckerberg ignored his appearance at the International Grand Committee, and now we have your report coming out, and Facebook says, thanks, but we don't want to spend any money to actually comply, so we just will pretend that you don't have jurisdiction over law. You referred to their policy as, quote, an empty shell. So I'm trying to figure out what is fundamentally wrong with Facebook. Is it the corporate culture, and which is, I'm not asking you to venture in on, or is it that their fundamental business model, like the fundamental business model of surveillance capitalism, is based on ignoring the privacy rights of citizens, and they just simply will not change a business model that has worked extremely well for them, even if it is breaking the law of Canada and numerous other jurisdictions?
It's clear that their business model, like the business model of many companies, is to monetize the value of personal information. That's the core of the issue, and we need, as societies, to develop the right legal framework to ensure that whatever service that actually adds value is maintained, but in a way that does not create harm because of the collection and ultimately surveillance, corporate surveillance of citizens.
It still protects the rights of citizens. So then finally, in order to prevent something like this in the future, so that when the Canadian regulator steps in and starts to investigate, because there will be other breaches, there could be other even more serious breaches, what tools are you asking for, if you need to repeat it to our committee so we can repeat it to the Parliament of Canada, the tools that we need so we can learn from the lessons of the Cambridge Analytica scandal, so we can protect the democratic and social rights of citizens in the who use online services?
So my recommendations are to give stronger enforcement powers to my office as the regulator, which means in practice at least three things: the ability, the authority to make binding orders, to impose penalties to make sure that these orders are actually implemented, and third, equally important, perhaps more important, the authority to proactively inspect the practices of companies to make sure that they actually follow the law. That's at the important mechanical step. But beyond that, we need to reform the principles of the private sector law and the public sector law, but now we're talking about the private sector law. I don't have a problem with the fact that the current PIPEDA is principles-based. It's part of the architecture that allows it to endure over time, regardless of technologies. But this principles-based legislation also needs to ensure that it is rights-based and defines privacy not as a series of important mechanical steps like consent, but defines the right at the proper level, which is the right to be free from unjustified surveillance by corporations and government. That's the right that's at play, and that's the right that needs to be enacted, I believe, so that citizens can engage in the digital economy, can make searches, can develop as persons in a way where they can do that without being subject to constant surveillance.
Thank you, Commissioner Therrien. Once again, it's never long enough, but we appreciate your appearing at our committee. For the committee's sake, we have committee business right away, so I'd ask to keep the exit as brief as possible. So 1 minute, we will suspend and we'll reconvene in, again, 1 minute.
Thank you.